Trigger warning, if you are a lawyer, you probably do not want to watch this video. But if you're not, or you just want your daily dose of schadenfreude, let's talk about what happened. This is every lawyer's absolute worst nightmare. Yes, a poor lawyer at the DOJ did the unthinkable. Not only did they file the wrong document with the court, that's bad enough, but they filed an internal, privileged memo containing their legal analysis of the case. And spoiler, the lawyers think their case is terrible. Yes, this poor lawyer filed a secret work product memo that explains in detail why they should lose the case. I don't think you can see it under my Indochino suit, but I actually have goosebumps. This is horrible. I am dying of Fremdschämen. This is every lawyer's worst nightmare. And other than stealing from your client, this is probably the worst thing you can possibly do to your client. So this all comes from the Metropolitan Transit Authority versus Duffy case in the Southern District of New York. This is the case where the Trump administration is trying to block New York City's traffic congestion pricing program. And in their complaint, the MTA describes the Central Business District tolling program this way, quote, a market-based user pay solution that has seen success in major cities around the world. The program accomplishes its aims by tolling eligible vehicles entering the CBD in order to encourage mass transportation and using that money to support the city's transportation infrastructure. In a matter of weeks, the program has already achieved remarkable results. Traffic congestion and commute times have materially fallen, more people in Manhattan's commercial districts and supporting the region's businesses, and the MTA's vital transit system is seeing the benefit of increased funding. Despite its obvious success, however, the Trump administration has precipitously and for blatantly political reasons purported to terminate the program, as then candidate Trump proclaimed he would do in his first week in office. The administration's efforts to summarily and unilaterally overturn the considered determinations of the political branches, federal, state, and city, are unlawful, and the court should declare that they are null and void. Now, I don't want to get into the weeds on this case. Suffice to say, the program was overwhelmingly popular with New York City residents, loved by urbanists, and hated by the commuters in New Jersey and President Trump for reasons. But the Trump administration's efforts to stop the program were always on dubious legal footing. Most commentators agree that the federal government would not succeed in stopping the state program. So the New York MTA filed suit in February of 2025, seeking to prevent the Trump administration from stopping the program. Fast forward a few months to April of 2025, there have been some various procedural issues, some conferences, an amended complaint, totally normal stuff. And on April 9th, the court issues an order that defendants shall produce the administrative record by May 27, 2025. Defendants shall inform the court by no later than April 23rd, 2025, whether they anticipate the administrative record to include any documents other than Secretary Duffy's letter dated February 19th, 2025. Okay, again, totally normal stuff. The court just wants to know if the defendants want to include anything in evidence as they move forward with motion practice, and the main piece of evidence was Transportation Secretary Sean Duffy's letter, where he lays out a whole bunch of reasons why New York needed to shut down congestion pricing. And New York procedure is a little bit weird in this respect. When you're communicating with the court or you need to make a request, then you basically write a letter to the judge, and if you need to submit a document, then you attach that as an attachment to the letter itself. So on the agreed upon deadline of April 23rd, the DOJ lawyer files letter addressed to Judge Louis J. Lyman from Dominika Tarzinska, dated April 23rd, 2025, Ray, administrative record, and April 20th, 2025, Secretary Duffy letter. As you can see from the docket entry, it contained the letter itself and an exhibit, the letter from Sean Duffy that was dated earlier. Now for background, this is the copy of the original PACER docket. PACER, or ECF, is the god-awful electronic system that lawyers use to file documents in federal court. It's so bad, it was out of date 20 years ago and it hasn't really been updated since. But the docket entry looks right. But what's wrong is the attached document. It is not the anodyne letter stating that they intend to supplement the administrative record. No, it's much, much worse. The thing that was attached was this. It's a letter with the U.S. Department of Justice letterhead. Okay, so far so good. But the person receiving it is not Judge Lyman. It's Aaron Hendrickson, Senior Trial Attorney, Office of Litigation and Enforcement, U.S. Department of Transportation. Oh God, this is an internal strategy memo. The letter starts off, quote, Dear Aaron, we write with respect to the above referenced litigation brought by the Metropolitan Transportation Authority against the U.S. Department of Transportation, U.S. Secretary of Transportation Sean Duffy, the Federal Highway Administration, and Executive Director of the FHWA, Gloria Shepard, to provide you with information concerning the litigation risk the DOT faces in defending the Secretary's February 19, 2025 decision, to provide you with information concerning 1, the litigation risk the DOT faces in defending the Secretary's February 19, 2025 decision, and 2, a process for terminating the CBD-TP agreement outside of the current litigation for DOT to consider. As discussed below, there is considerable litigation risk in defending the Secretary's February 19, 2025 decision against plaintiffs' claims under the Administrative Procedure Act that the decision was contrary to law, pretextual, procedurally arbitrary and capricious, and a violation of due process. For the reasons outlined below, it is unlikely that Judge Lyman or further courts of review will accept the argument that the CBDTP was not a statutorily authorized value pricing pilot under the Value Pricing Pilot Program. Oh no! This is an objective memo talking about all the weaknesses of their case. It continues. The Secretary provides two reasons why the CBDTP is not an eligible pilot project under the VPP statutory language. One, the program constitutes impermissible cordon pricing, which is not authorized because it does not offer a toll-free option. And two, the level of CBDTP tolls has been set primarily by the need to raise revenues rather than prevent congestion. Neither of these reasons is likely to convince the court. First, with respect to the rationale that cordon pricing is not authorized under the phrase congestion pricing or value pricing, we have been unable to identify a compelling legal argument to support this position. Oh no, they're admitting that their arguments are bad. Now, if you inadvertently revealed your trial strategy to opposing counsel, you're probably going to want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle team, help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team, because you don't just need a legal team, you need the Eagle team. It continues yet further. As a result, it is unlikely that courts will narrowly construe the term congestion pricing to exclude cordon pricing projects based on the long-standing prohibition on tolling alone. Yikes. It continues. Although DOT's interpretation of the statutory language cannot bind a court may still look to the long-standing practice of the government, like any other interpretive aid, to inform the court's determination of what the law is, citing Loper Bright. Now, this is funny just as an aside because it was a right-wing cause célèbre that the court did away with called chevron deference, where the courts would defer to an administration's interpretation of regulations, and the Supreme Court just did away with that. Here, the administration absolutely would have wanted the court to defer to the Department of Transportation's interpretation of its own regulation and law, but they can't now because the Supreme Court says it doesn't really matter what the agency thinks. It only matters what the court thinks. But they continue further. The Secretary's letter further asserts that cordon pricing in this context is impermissible because it, unlike other congestion pricing strategies, does not provide a toll-free option. As outlined above, the legislative history and FHWA's prior guidance implementing the VPPP undercut this assertion. It is very unlikely that Judge Lyman or any court of review would agree with that assertion. Ouch. And the letter goes on. Second, with respect to the argument that the CBDTP is not authorized because the VPPP does not authorize tolls that are based on considerations separate from reducing congestion or advancing other road-related goals, there are two impediments to this argument being successful. It is very unlikely that Judge Lyman or further courts of review will uphold the Secretary's decision on the legal grounds articulated in the letter. Defending this case on this basis, with the most likely outcome being vacatur of the Secretary's decision or remand to the agency for further administrative process, will only serve to delay FHWA's elimination of the CBDTP. The agency will have to answer the MTA's and interveners' complaints, compile and produce the administrative record, and then the parties will engage in briefing, likely oral argument, and await a decision from Judge Lyman, which is exceedingly likely to be adverse to the agency. I can't imagine filing this memo. I don't know what I would do. I would commit ritual seppuku. I would absolutely just stick a sword in my stomach and just, pull up. This is the most horrible thing I can think of as a litigator. It is the most horrible thing you could possibly do unintentionally to a client to file this strategy memo. And look, this strategy memo is totally normal. There's nothing wrong with it at all. The client needs to be fully apprised of the strengths and weaknesses of their case. The DOJ is bound to deal with their client, the federal government, and in particular the Secretary of Transportation, Sean Duffy, and they have to zealously advocate to the best of their ability. So totally normal that you would put together an objective memo talking about the strengths and weaknesses of your particular case so that there can be internal discussion about the best way to move forward. But that analysis should never see the light of day. I'm shivering. It's so horrible. It's secondhand embarrassment. I'm going to die. But let's keep going. The letter continues. While there is considerable litigation risk in defending the decision to terminate the CBDTP based on the argument that it is not a statutorily authorized value pricing pilot under the VPPP, FHWA may be able to accomplish the same goal for the same reasons, utilizing established OMB procedures for the termination of cooperative agreements. Now, this argument is probably dumb too, but it's not really worth explaining here. And the DOJ lawyers are probably right that it makes more sense to go down that route than it does to actually try to defend Secretary Duffy's original letter. But basically, you get a window into the strategy of the DOJ. The inadvertently released memo goes through their entire strategy and explains that their arguments are bad and that everything the Transportation Secretary Sean Duffy said was stupid. Now, I want to make clear here that I don't think the lawyers did anything wrong here other than file the absolute worst incorrect document they possibly could. As lawyers, you have to zealously advocate for your client, and they were probably boxed in by the statements of the Transportation Secretary Sean Duffy into what legal arguments that they could make, and they were trying to make the best of a bad situation by saying that the arguments that he forced them to make were probably not going to win, and they had a better legal strategy that they thought they should use. And even if the original legal arguments were losers, well, sometimes as lawyers, you want to make every argument that you can, and some of them are going to win, some of them are not. So you kind of roll the dice. That's a totally normal thing for a lawyer to do. Now, the lawyer who putatively filed this was Dominika Tarczynska. She appears to be a 10-year veteran of SDNY. She's probably not a Trump hack. She probably just had the absolute worst day of her life. Though it also might not have been her. She seems to be fairly senior at SDNY. It's entirely possible that a paralegal, secretary, or a junior attorney made this particular filing. Lawyers who litigate in federal court give our PACER logins to staff all the time. I myself have relied on legal secretaries and paralegals to have filed many filings in federal court. But the thing is, if you give your PACER login away to someone who then files something in federal court, you're still on the hook for whatever gets filed. You have to supervise them. And as I mentioned before, the PACER system is terrible. It's incredibly clunky. It's not surprising that things get filed on accident by mistake. And I'm sure that that's what happened here. This is an honest mistake, a real screw up. And I feel terrible. I feel so awful to even talk about this. This is the kind of thing that could happen to everyone. I'm sure the file name said, Transportation Secretary letter. And, off the face of the file name, it was probably possible to confuse these two things and just attach the wrong PDF. That absolutely does not excuse the screw up, but it does help explain things. Now, what looks like happened here is that pretty soon after this thing was filed and started making the rounds on social media, it looks like they called the clerk and asked the clerk of the court to take this docket entry down, and the clerk did so. There is no longer a docket entry number 65 on the public docket, but of course the damage was done. If this was private practice, you would immediately file a letter with opposing counsel and the court seeking to claw back any document that was inadvertently released, and you would probably immediately get on the phone with your malpractice carrier and explain that you did a malpractice and that they might need to make some payments on the insurance policy for malpractice. And that's exactly what happened here. The lawyer issued basically a clawback letter explaining everything to the court, explaining that she had reached out to the clerk to take the original docket entry down. Opposing counsel didn't oppose and moved to seal the inadvertent filing so no one could see it on the public docket ever again, though at that point the horse was out of the barn. In this particular litigation, the document was taken down. There was a follow-up filing that included the correct letter. And I'm sure what's going to happen is that everyone is going to pretend like this never happened. This is pure legal analysis and strategy. So it's not like they are admitting that they suborned perjury or that they are holding on to evidence that they didn't turn over to the other side. Everyone's just going to pretend that they didn't read it after they, of course, did read it. And I don't really think this is going to affect the rest of the litigation. People are probably going to get fired over this. It's unbelievably embarrassing. And like I said, it's the worst thing that I can imagine doing inadvertently. The only thing that I can think that comes close to this is when Alex Jones's lawyers accidentally turned over gigabytes of phone data that they absolutely refused to turn over to opposing counsel. And then Mark Bankston cross-examined Alex Jones and used the evidence that his lawyers had turned over. This, I think, is still worse because this isn't just evidence. This is internal trial strategy and legal analysis. But for the sake of professional courtesy, I'm sure everyone from opposing counsel to the judge we'll just pretend it never happened. Notwithstanding, I'm sure that this poor DOJ attorney wants to crawl into a hole and disappear from the internet. And luckily, there are people who can help, and that's why we recommend signing up for today's sponsor, Incogni. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. Now, they can't undo an inadvertent filing that revealed your entire client's strategy, but they can help you with removing personal data. And if the data brokers resist, Incogni will help take care of that too, because Incogni fights back. And you can use my link in the description or the code LegalEagle for an exclusive 60% off discount. Now, these data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address and phone number and extensive history. It's shocking to see just how much information is out there and how easy it is to find. And it also might be why you're getting so many spam calls lately or how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years. In that time, you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you to Incogni for saving me days of time and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it again. Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link that's on screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. And if you do decide to keep it, you'll still get the exclusive 60% off discount so long as you use my link or the code LegalEagle, all one word. So after you sign up for Incogni, click over here for more LegalEagle, or I'll see you in court.